Good afternoon, 7 minutes after 4 o'clock. You're tuned to Money Radio, 1510 AM and 99.3 FM. Name of the program, Financial Review. My name's Sinclair No. Today on a special edition of the review, we'll talk with Laura Bramnick from TalkRealEstateAZ.com. Later in the hour, our guest is Dan Nichter from Payson Petroleum. We'll be talking oil and gas. We've got lots to cover. Today is Thursday, December 19th, 2013, the only day like it ever. Hope it's been a great day for you. Thank you for joining us for the Financial Review. Let's get down to business. Thank you for joining us, and let's welcome our guest this hour. We start with a familiar voice on Money Radio and the Financial Review, and that is Laura Bramnick. Laura is an attorney and a realtor and a consumer advocate, and she's our regular guest here on Thursday afternoons. We're taking the entire first half of this hour with Laura, though. And Laura is from TalkRealEstateAZ.com. That's her website, TalkRealEstateAZ.com. Laura, in addition to being an attorney, has over the years been a real estate investor, worked in the mortgage industry. She has an active Arizona real estate license, and she is a certified instructor with the Arizona Department of Real Estate. If you'd like to call and talk with Laura, 480-624-2705, 480-624-2705. Laura, good afternoon.
Good afternoon, Sinclair. Great to be here.
Good to see you again. And we welcome to the studios today Jim Knollmiller. Jim Knollmiller is an attorney who I had the opportunity to meet a few months back at our panel of professionals meeting that we had in Scottsdale.
That's correct.
And you've worked with Jim over the years as well.
Yes, and both of his partner and one of the attorneys in his office. And they're a great team.
You are from the firm of Knollmiller and Aronofsky, LLP. And you're also a certified tax specialist in addition to being an attorney. Knollmiller and Aronofsky, based in Mesa on Alma School Road. Jim, good afternoon. Good to see you again.
Good afternoon. Good to see you again.
We've talked about, and this is important because I think particularly this time of year, a lot of folks are getting together, seeing family that maybe they haven't seen in a while. It's probably a good time to talk about some issues that also relate to real estate, Laura. And I'm sure you run into this on a regular basis. Estate planning issues crop up in real estate issues all the time.
Yeah, many times clients will have investment properties or commercial properties, and they'll say, what do I do if I die? What's going to happen? Mm-hmm. I don't know if my wife or my kids or whoever are my beneficiaries can take over the management of my properties.
And have they done the paperwork required to allow them to take over that?
Exactly. And a lot of people think, well, I have an LLC and that suffices. But as Jim will tell us, that is not the case.
There's much more to it, isn't there, Jim?
Yes, there's a great deal more.
Let's talk about, first of all, just the basic idea of what we're really talking about when we talk about an estate plan. What's involved?
Well, generally, what's involved in an estate plan, you want to decide what property you have, where it's going to go, and the mechanisms you use are wills, trusts, you have powers of attorney, and you have what we call living wills and medical powers of attorney, all make a plan for your estate.
So the basic idea between a will and a trust, let's explain the major difference there.
Well, simply a will is instructions that you give and has to be probated in court, and then the court will then use your will to direct how your property is to go. Where a trust is more of a private document, you'd still direct how your property is to be distributed, but it doesn't have to go to the probate court to be administered.
So the will, you described it, and it's interesting the term that you used, instructions to the court. You can give instructions to a judge, but I don't know that the judge necessarily has to follow those instructions.
Well, that may be a little bit misnomer saying instructions, but it's basically guidance to the court as far as what you want done with your property and who you want appointed to handle this administration of your property.
And that process, though, is a public process, and essentially you are at that point turning it over to a judge to make that determination.
That is correct. I mean, a judge sort of is he rules the court, and if he makes a decision, you have to follow that decision. We've had cases where a judge made a decision in a case that all the beneficiaries disagree or wanted to do something, but he wanted something else. So the judge said, "No, this is what I want."
Split the baby, in other words.
The judge is sort of he has the final word.
Yeah, they always do. Whereas with a trust, it is a private document, and you allow for a private line of succession.
That's right. You name people who are going to act for you, either if you become disabled or pass away, and then you also provide the instructions in the trust document as to what that you want done regarding yourself. So should you become incapacitated, and what's to be done with your property, particularly when you pass away.
And when we talk about property, it's not just real estate. It can be a variety of assets. But there are some specific limitations when it comes to real estate in Arizona and in most states. If you hold real property, real estate, there's a good chance that it will go through a probate process unless you have that private process through a trust or some other form of succession set up.
That is correct. You need to have some form of way for that property to be distributed to someone else. For example, if you leave the property just in your name, and you pass away, the only way that property can be transferred is that you end up having to have a court issue documents that will permit that property to be transferred.
One way that I've always looked at this is you've got to have somebody to sign the paper to transfer the ownership. And if you're not around to sign that paper anymore, then there are only a couple of choices. Either someone that you have already assigned that authority to in the form of a private document like a trust, or the judge can assume that authority and sign and transfer that property.
Yes, that's correct. That's essentially what you have to have. You have to have somebody to be able to sign the papers.
In addition, you mentioned some other documents in there. A living trust, powers of attorney. This is for when someone is still alive, but for some reason or another, through incapacitation or something else, is unable to sign and control these areas for themselves.
That's right. Power of attorney, you designate someone to act for you, generally when you're incapacitated. You're no longer able to act for yourself, so you now name the person you want to act for you. A medical power of attorney is similar, except it's for medical decisions. You have what we call a living will, which basically says, here's what I want done in case of if I'm unable to make the medical decision myself.
Do not resuscitate or plug me into every machine you can think of. Whatever that personal decision is, you have to put it in writing.
That's right. You need to put it in writing, and then the person who has the medical power of attorney has the legal authority to tell the doctor and hospital to either what I call pull the plug, if that's what you want,
right,
or to take every measure to keep me alive.
Okay, so these are all very important issues. And even if someone doesn't have a large estate, a big portfolio, some of these things are very important to have in place. Just some decisions on who can pay some bills in case I become incapacitated. What kind of medical treatment should I receive if I become sick and can't direct the doctors myself?
That's correct. I mean, again, things that are in your name alone. If a check is made out to you, somebody has to be able to endorse that check. And if you can't do it yourself, somebody has to have that legal authority. If you can't make a medical decision regarding your care, someone needs to make that decision. And you need to get it. You want to make that decision. Who makes that? You want to be able to name the person that's going to be able to make that, rather than having a court do that.
And we've always heard of trust, and we kind of associate that with the very wealthy. The Rockefeller Trust, whatever it may be, something like that, the Ford Trust. But what you've just described to me is something that is probably of greater importance to an average family.
Well, that's correct. I mean, most of our clients are not very wealthy people. They're not multimillionaires. They're people sometimes with young children. What happens if you have young children and the parents both are killed in an accident? Who is to take care of those children, to be their guardian, and who is to manage any funds for those children until they're adults? This is one of the many things you need to consider in having trust. Also, if you have a modest estate, you need to decide. If you don't, the state of Arizona has a plan for you.
Oh, yes, they do.
And that plan means that you'll have to go to court. You'll have to have a judge. You'll have to have attorneys involved in the court, and it can become an expensive and long process. Where if you even have a modest estate, a home, some securities, bank accounts, and you spell out who gets it and what time they get it. Maybe do you want your child to have all that money at age 18?
Maybe spread it out over several years after they reach the age of majority.
That's right. I have very few times ever seen a client who leaves a large chunk of money to an 18-year-old. If you can remember when you were 18, what would you have done if you had suddenly been given several $100,000?
I would not have invested it quite as wisely as I would today. But many times we think of trust, and the issue of the estate tax or death tax comes into play. That really only applies for a single person. What is it, $5.3 million?
That's right. In 2014, the exemption is $5,340,000, but the tax, once you get over that, is 40%. But the majority of the clients that I deal with do not have an estate tax issue because their estate is less than $5 million.
And for a married couple, you could essentially double that to $10.6 million.
And $10 million for a married couple. Now, the married couple needs to do some planning.
Yeah, but you could take advantage of that.
Yes.
But most people don't fall into that, but they still need to do some estate planning. A trust may be a very appropriate vehicle for them if they have real estate. And one reason why this comes into play, and Laura, I know you've seen this from time to time. Somebody passes away, maybe they have a rental property. Who collects the checks?
Yeah, there's a lot of issues that come up with that because who pays the mortgage? In other words, you may have the property and the tenant maybe isn't paying, or maybe it's just your primary residence, and you have to have somebody to be able to get to funds to pay the mortgage. I have seen many times where the house has gone into foreclosure or nearly into foreclosure because there wasn't forward enough thinking about, okay, I'm going to leave my property to my spouse or to my brother or whoever it is.
And it's so important that you figure that. I want to follow up with you a little bit on that. As we continue our conversation, we're talking with Laura Bramnick, of course, from TalkRealEstateAZ.com. Laura Bramnick, a regular guest on Thursdays, and our special guest today, James Knollmiller. He's an attorney with Knollmiller and Aronofsky from Mesa. We'll continue on the review after this. Money Radio, we're talking with James Knollmiller and Laura Bramnick from Talk Real Estate AZ. Laura Bramnick, of course, our regular guest on Thursday afternoons. Today, our special guest visiting us in studio, James Knollmiller from Knollmiller and Aronofsky, LLP. We've been talking about estate planning. Timely, I think, this time of year as families are getting together. Right before the break, Laura, we were talking about the idea that so many times there are questions if someone passes. Who has the authority to pay a mortgage?
Right.
Who has the authority to collect rents?
Right.
And if that's not written down as part of an estate plan, it may not be such a simple thing to just say, oh, I'll pay.
No, you need to know where the leases are if you have tenants, and it's not unusual sometimes to have oral leases. Not everyone sees a lawyer to set it up properly. First of all, you have to have access to funds to pay the mortgage company, I don't mean to say this in a nasty way, but they don't really care if the person's incapacitated who is responsible for the mortgage. They want their money. And so the issue is, how's that mortgage going to be paid? And if the property needs upkeep, or, the air conditioner could break in the summer.
And we've talked about this. If there are some late pays and then someone else other than the mortgage holder tries to come in and pay,
right,
they may or may not accept that.
the money. That's exactly right. Now, also, once the mortgage company finds out that someone has died and the property gets transferred under the will or the living trust, many lenders see that as a transfer that violates the due on sale clause, and they may want that mortgage paid off or refinanced in some way. And so you just can't assume that if you continue to make the mortgage payments that everything will be okay.
And Jim, if a property is transferred through the probate process, going through the courts and the judges, that we've seen this can usually take quite a bit of time.
That's correct. I mean, it can take 6 months or more. In fact, if you don't have things properly set up to do a informal probate, you have to wait 6 months on real estate to be able to probate it.
And we've all heard cases, that have gone on for years and years. Some of these celebrity cases. I think Marilyn Monroe's probate lasted for 15 years or so.
That's correct. I mean, it's unusual to have that happen, but yes, it can happen where probate will take a long time, because when you start getting people contesting things or people wanting to be, you now have 3 people wanting to also be the representatives for the estate, and they all go to court fighting over who's going to be the representative, and you haven't even got anybody to do anything yet. You're just fighting over who's going to be able to do it.
Now, by contrast, if you do the proper estate planning and you have powers of attorney for incapacitation, if you have a living trust, how long does it take to transfer over something like that at that point?
Okay, in the living trust, basically you name the person who's going to succeed you if you pass away.
Successor trustee.
The successor trustee.
Yeah.
And that person can act immediately. Now, the only problem they have is normally they have to be able to prove that you're dead.
So they need a death certificate.
So they need death certificates, which will take somewhere about a week or so from your death to get one from the state. But once they've got the death certificate, I've had people, particularly where it was an estate where the trustee, or the successor trustee, was also the sole beneficiary. They came in. I said, "Fine, you can do anything you want." They turned around and sold everything, the securities and everything, within the next few days. So within a couple of weeks of the person's death, they had sold everything they wanted to do.
So literally, it could be within a week or two, everything could be resolved, as opposed to 6 months or on.
That's great. Now, that doesn't say everything's resolved, because obviously you've got to file final tax returns for individuals, and you have to do other things, but it means that person can act and do these things pretty well immediately.
Well, here's another good point. You are not only an attorney, but you're also a certified tax specialist.
That's correct.
A lot of tax issues come up with an estate plan.
That is correct. Not only, the estate tax is one issue, which under the current exemption mode is a relatively minor issue for most clients. But finding most clients now have retirement accounts.
An IRA, 401k.
Yes.
Yeah.
An IRA, 401k. Okay, when you take the money out of your IRA or 401k, you pay income tax on that. When you pass away and you've designated someone to be your beneficiary of that IRA, and they take money out, they have to pay income tax on it.
Yep.
But that becomes a planning point, because that person, if you've done it properly, can stretch those payments out, not take it out in one lump sum, but take it out over their lifetime, and defer the taxes for sometimes 20, 30 years or more.
Whenever there's a transfer of properties or assets of any value, there are tax considerations at the very least. Maybe not a tax payment, but considerations.
There are tax considerations. Again, we talked about, back to real estate or any other property. Say you bought the house for $20,000 40 years ago, and it's now worth $200,000.
Capital gains.
When you sell it for $200,000, you have $180,000 gain. However, your heirs, when you pass away, get a step up in basis to that date of death value of $200,000. And this holds true for all other assets. So
it's important to know all this. It's important to know this. It's important to follow up, I would say. And you're offering our listeners today a complimentary proposal for an estate plan. Talk it over, figure out what you have, what you might need, and how you might be able to assist them. You can do this over the phone to get things started and find out more information. 480-861-7743. 480-861-7743. And you can also visit the website aboutestateplanning.com. aboutestateplanning.com. But start with the phone call, and then if you need to follow up on that and put together an actual plan, you can come out, visit in the home, go over the entire process with them. Jim, good to see you again. Again, that phone number, 480-861-7743, and the website aboutestateplanning.com. Laura Bramnick from talkrealestateaz.com, where we also have archives of our radio programs posted. So if you missed something, you can go there and follow up and listen again. talkrealestateaz.com at 480-624-2705. Laura, always a pleasure to see you and always good information. Happy holidays.
Same to you, Sinclair.
Thank you, Sinclair.